This Honorable Court of Criminal Appeals is now in session.
Thank you very much, Madam Clerk, and welcome this afternoon to the Tennessee Court of Criminal Appeals. This is the May docket, and we are conducting oral arguments both today and tomorrow on the Zoom, in the Zoom format, and it's available. These arguments are available through the AOC website, I think on YouTube, and we very much appreciate the technological skills of Barbara Peck and her staff for allowing us to be able to conduct oral arguments in this fashion. All of us are looking forward to getting back into the actual courthouse for arguments, hopefully in the very near future. That being said, my name is Robert Wiedemeyer. I live in Nashville. I'm on the middle section of our court. And the panel today, I have two distinguished colleagues, both from the western section, Judge Camille R. McMullen from Memphis and Judge J. Ross Dyer from also from Memphis. So it's an honor to serve with those two jurists. Attorneys, I think probably both of you have been in this court before. You know the procedure. We're going to use pretty much the exact procedure we would use if we were actually in the courtroom. Each side gets 20 minutes to argue. For the appellant, if you wish to reserve any rebuttal time, let me know and I'll try to keep up with the time and let you know how it's going. I think that's all I need to say to get this thing started this afternoon. Madam Clerk, are there any preliminary matters before you call the first case on the docket?
None that I'm aware of.
All right, thank you very much. If you'll call the next case then.
State of Tennessee versus Bret A. Wines.
Good afternoon. Good afternoon, Your Honors. May I reserve 3 minutes for rebuttal?
Certainly.
Thank you.
You're welcome.
As I said, good afternoon, Your Honors. I am Francis X. Santori Jr. from the Greene County Bar, and I'm representing the appellant Bret Wines. The issue that I want to argue today, and I know we've posed a lot of issues in our brief, but the one that I wanted to reserve for argument today can be succinctly restated as this. Was it plain error for the trial court below to hold a probation revocation hearing by Zoom? And we most respectfully state that it was. First of all, Your Honors, Article 1, Section 9 of the Tennessee Confrontation Clause, according to our case of State versus Deuter, which is 839 Southwest 2nd 391 at 395. Yes,
Counsel,
yes, President Mullen.
This is going to come off as funny, but I want to make sure your client doesn't have a problem with us having this proceeding by Zoom.
Well, Your Honor, I would think that an appellate procedure is a little bit more different than a trial procedure, if Your Honor, please. And I think Your Honor can sort of guess that. And I know where Your Honor was going to go. I knew one of you was going to say that.
He conceded at the top of the hearing that he had no problem with the Zoom revocation hearing. So I just want to make sure that we're consistent.
Well, we are, Your Honor, but I think that it was plain error, most respectfully.
Let me ask you this: what proof?
Yes, Judge Dyer.
What proof was put on at the hearing? What proof did the state put on to establish the revocation or to establish the violation?
Judge Dyer, I'm sorry, Judge Dyer. I apologize for talking over you. Slap me down if I did. It's sort of difficult in this technology not to talk over people, and I apologize to the court. The proof that was put on was largely his basic violation of probation by being convicted and charged with other crimes.
Well, so let me ask it this way then. Did the probation officer testify, or did they just introduce the document showing he had been convicted? And then two, did he testify and concede to the violations?
Well, I apologize, Your Honor. I didn't want to mislead you. He conceded the violations. We wanted, though, to put on proof as to what the punishment should have been, because to be quite honest with this court, there was a lot of overwhelming evidence of the prior violations.
Well, if no one testified but your client, where's the confrontation issue?
Well, we believe that it comes and it's inherent in the seal case. I know the court may say, well, where is the confrontation and the confrontation of witnesses? I think that he has a right to appear at any critical stage of the litigation, and that might be the most important thing rather than the confrontation issue. He has a right to appear at any
But he
critical.
expressly waived that right. That's what I'm having trouble with. He expressly waived it. And I know you responded that this is plain error now, but he expressly did that. And he can't come back now and take advantage of not being present when he expressly waived it. That's tactical, and you fail on plain error in that way.
I would most respectfully concede to the court that it was not my tactical decision. It was his tactical decision, basically. Okay. I certainly.
Well, you represent him, counsel, in all fairness, and you can't separate yourself from the case in that way. If you could speak to that line of I guess, argument from my perspective, because I'm looking at this case and I'm just shaking my head when I'm reviewing your argument in the brief, because you understand what we're going through with COVID. You understand that there were no issues of any, I guess, there weren't any issues that were contested at the hearing other than the length of probation that he was going to serve, or the length of incarceration that he was going to serve. So I was a little concerned about what we were going to hear today.
Well, yes, Your Honor. Maybe then I ought to confine my argument then, since the court has already sort of telegraphed its signal as to the length of the particular sentence that he received, which might be a better argument to be heard before this court than basically the confrontation clause and the reversal. And that's fine, and we can certainly address that if we may, Your Honor, please.
Sure.
That would be all right.
Your argument.
All right. Thank you, Your Honor. Well, Your Honor, Your Honors have seen, and this might short circuit this, and Judge McMullen might have short circuited this for me, but Your Honors have seen the comparative sentences that have been rendered and meted out to similarly situated persons, such as my client, Mr. Wines, who is basically a nonviolent felon and basically a drug addict. Now, he gets 14 years, most respectfully, and is forced to flatten 14 years for something that is a nonviolent felony and something that basically is I'm not going to say that it was a technical violation. I think it was a little bit more than a technical probation violation, but for picking up another crime, which was a nonviolent felon and involved drugs, he's going to get 14 years. I would most respectfully state that with respect to the sort of data that I presented to this court from its own administrative office of the courts, that sort of sentence that was meted out by the honorable trial judge was not in line with what has been received by other similar people.
I appreciated that section of your brief. I appreciated you illuminating, the appropriate sentence or what other individuals had received for that type of offense. And I think that's the appropriate way to look at sentencing. However, what you failed to include in that section of your brief is that your client was he a range 2 or range 3 offender? And this
He
is
was
something.
arranged. I'm sorry, Your
range
Honor. He
two?
was arranged too. Yes, he was.
And so part of the enhancement of his sentence was not due to anything that the trial court did. It was due to his prior history and due to whatever agreement he entered with the state based on his prior history. Would you agree with me?
I would agree with you, and I would agree that that was what his prior attorneys did. That's all that I'll say without any
All
comment.
right, I understand.
Okay. Well, with that in mind, and again, Judge McMullen, I think you short-circuited this argument. It's the first time that I've been before you, Judge McMullen, but I think you short-circuited this argument. I was really going to come in here prepared to argue more about the confrontation clause or the lack of appearance, but if the court had basically decided that, and this court is telegraphing this to me already, I will stand basically on the sentence argument. I do understand that he is range 2. I do understand that his sentence was enhanced either by agreement or by prior sentencing. Yet I still believe that to flatten his sentence for this amount was just a wrong thing. Now,
Mr.
maybe,
Santori, you
yes, Your Honor.
indicated that I've telegraphed something to you. I've asked you nothing but
Yes,
direct questions. If you have
Oh, I
anything
know.
that you want to add in terms of what, I guess, how there was prejudice to your client or how it was not a tactical decision for your client to expressly waive his appearance at the hearing, I'm more than happy to hear it.
Sure, Your Honor. The only thing that I can say again with respect to that, and I meant no disrespect to the court. I hope you didn't think I meant any disrespect to the court when I said
No, I
was,
didn't.
you
I
know,
didn't.
the
I just
court was
wanted you to
telegraphing.
understand that you have the opportunity to make whatever argument you want in addressing my question.
Yes, Your Honor. Yes, Your Honor. And I guess I would think that the only thing that the court could find that it was not a plain error was that it was tactical. And the only thing that I could add to that is that he definitely met 4 of the 5 requirements, or 5 of 6 for plain error. I can tell you that I didn't seem to remember waiving it. I was not, I stand to be corrected. Honestly, I do. But I don't seem to remember that as being a matter of tactics on our behalf. And with that in mind, if the court has any other questions of me, I'll be happy to answer them right now.
I just have one on the sentencing issue. You know, not only
Yes,
is he not only is he range 2, and is this a prior deal he made, but he has numerous violations. It's not like this was his first strike and the trial court just dropped the hammer and said flatten 14 years. He has numerous violations. At some point, even someone like your client who clearly has a severe drug problem, don't we have to say maybe the better place for him to get healthy, to get well, is to be incarcerated rather than on the street where he clearly is continually tempted and continually violates the law?
well, Judge Dyer, to answer your question, I'm going to give you a third alternative, most respectfully. The best place that this young man can be is where he has never been before. It's in long-term treatment and rehab. And we're not talking a 3 or 6 month wonder. We're talking about a year, perhaps 2 years. He has attempted to get this before. No one has ever given him this chance to get this before. He is quite simply, and I apologize if I'm feeling, and I'm not supposed to feel personal because of this, and I'm not trying to be, but he is most respectfully, Judge Dyer, a drug addict. He may be a criminal, but he's more of a drug addict than a criminal. So to answer your question, sir, the third alternative would be best. Let's put him in long-range drug rehab. let's don't keep him out on the streets. No, we don't want him out there, but let's not throw him in jail for 14 years.
Did he ask for long-term rehab this time or any other time?
He has asked for long-term rehab this time. In this particular case, he did. And the judge, I cannot speak, to be quite honest with you, as to the prior times, because I was not his counsel until this particular time.
Okay.
All right. And that's all I had, Your Honors. If the court has no other questions, I may rebut for 3 minutes, but I may not. Thank you for your time, Your Honors.
All right, thank you, Counselor. You still have your rebuttal time if you wish to use it. General Spangler, are you ready?
I am, Your Honor. Thank you. Good afternoon, Your Honors. May it please the court. Nick Spangler for the state of Tennessee. Since the defendant essentially concedes waiver of this challenge to the revocation hearing being conducted over video conferencing, the state only argues that conducting the revocation by video conference did not create any plain error. And we essentially argue two of the plain error factors. First, the trial court didn't breach any clear and unequivocal rule of law by allowing the defendant to expressly waive at the start of the revocation hearing any confrontation right that applied to that hearing. It's well established that constitutional rights can be waived, and specifically that confrontation rights can be waived. And I think, as Judge Dyer was pointing out or getting to, there's really no confrontation right implicated in this case, since the state didn't offer any witnesses for the defendant to confront at the revocation hearing. Again, this was a situation where the defendant at the start of the hearing conceded all basis of violation, essentially all the allegations in the violation warrants, and then proceeded to put on some proof in the form of his own testimony about disposition, that is, the consequence of the violations or the revocation. But the state did not call any witnesses or really put on any proof during the revocation hearing. It was limited to the defendant's stipulations to the violations, and then his testimony about his preferred disposition of those violations.
Mr. Spangler, if I could just ask the question,
Sure.
This trial court, did they have a procedure for litigants, especially litigants who were in custody, for the option of a Zoom hearing or to wait until in-person hearings resumed? Because I know our practice is similar to that. Our practice is, if you would prefer to wait until we're back in person during the pandemic, you have that option. Do you know of any of the practices of this particular trial court?
Unfortunately, I don't, Your Honor. It's first of all, I'll say that it's definitely not something that's in the record. It's actually interesting. There's only very slight indication in the record that this was done by Zoom. Obviously, we have the defendant's waiver on the front end saying he waives his right to be present. And then there's a very brief allusion to the fact that this is being conducted by Zoom toward the end of the hearing. And really, that's all the record says about this issue at all in terms of why it's being conducted by hearing or anything like that. And I didn't do any sort of behind the scenes digging to see what this particular district's practice is with respect to holding these hearings by video or not. I'm not aware of that, Your Honor. And like I said, it's not in the record, so I'm sorry, I can't be more informative on that issue. But
I just have kind of a procedural, just because I have yet to see one, I guess. The record in this case, did they record these Zoom hearings and did they make that a part of the record? Or is it a transcript? Like, otherwise I wouldn't know that it was a Zoom hearing, other than the fact, like you said, there's two comments to it.
Again, I can comment, at least as far as the record is concerned, that there was no exhibit or video exhibit or anything of that nature in the record capturing the video of this hearing taking place. Obviously, we have the transcript of the dialogue that was taking place. But other than the recording for the purposes of creating a transcript, I'm not aware that there is any other video recording of this. At least that's not in the record. And again, I didn't do any digging behind the scenes to see if that's the practice in this particular district. So again, there are no confrontation rights really implicated here, as you pointed out, Judge Dyer, because there was no state's witness that was called at this hearing. And then the second plain error factor we rely on is the defendant really can't show that this waiver was not tactical. We submit that the affirmative nature of the waiver, again, at the very start of the hearing, suggests that it was tactical. And then the pandemic concerns acknowledged by the defendant strongly suggest that the waiver was based on the defendant's own personal safety, own personal health interest. That's kind of sort of self-evident from the hearing that that's why he was agreeing to waive this for the purposes of his own personal health and safety and that of everyone else involved in this hearing. So for those two reasons, we submit that plain error cannot be shown for this issue, that it's waived, and that plain error cannot be shown for this issue. I will briefly go on and talk a little bit about the revocation itself and the disposition for that revocation. The trial court acted well within its broad discretion by fully revoking the defendant's probation based on his admission to several and repeated violations of the term of his probation. Again, defendant stipulated to all allegations of all 4 violation warrants that were pending against him. And those allegations in those warrants included allegations of new offenses, failed drug screens, use of illegal substances, and failure to report, just to name a few. There were others, but those are kind of the big red flag violations that were alleged that, again, he stipulated to. And then we submit that full revocation was well within the trial court's broad discretion based on these admitted violations, and that full revocation was a rational consequence given defendant's lengthy history of criminal conduct, as well as his failed attempts at probation and parole. Again, that proof came in by way of the defendant's admission on, I believe, on cross-examination to having a significant criminal history, including multiple misdemeanors that dated all the way back to the early 2000s. And then he also admitted to a history of failed attempts at probation and a history of parole violations. So given all that proof by way of his own admissions, we submit that full revocation was within the court's discretion and reflected a rational exercise of the court's discretion in this case. I'm happy to answer any other questions the court may have. Otherwise, we just respectfully ask that you affirm the judgments of the trial court. Thank you.
All right. Thank you, General Spangler. Mr. Santori, do you wish to make any rebuttal comments?
No rebuttal, if Your Honor, please.
All right. Thank you both counselors for your presentations today. We'll study the record and consider your arguments and the briefs and render an opinion in due course.
Thank you, Your Honor.
Thank you. Certainly. Madam Clerk, I think we'll be in recess until the next case, which should be at 1 o'clock Central Standard Time, or and a little less than an hour from now. Let's put it that way.
This
All
honorable,
right. Thank you very much.
pardon me, this Honorable Court of Criminal Appeals is